This is Dr. David Shine, and welcome to Business Law 101. Now, one of the most common ways that any of us acquire a property is with a mortgage. And so the way that the starting point is you need the names of the mortgagor and the mortgagee. And I want you to look at these terms carefully because they may be intuitively to you a little backwards to your thinking. The mortgagor is you, the owner. The mortgagee is the bank or finance company that is providing the mortgage money. So mortgagor, the homeowner, mortgagee, the finance operation, who's ever financing it. So that's number one in a mortgage, also called deed of trust. You must have a legally binding description of the property. So the street address sometimes can be vague, but there's nothing vague about the fact when you say, it's block this, lot this, of this particular survey. That's pretty compelling evidence of a correct description. So some of the other things, again, names of mortgagor or mortgagee, a very accurate description of the property. What are the terms of the debt? Many of us with such low interest rates are moving away from the traditional 30-year residential mortgage to 20 or 15 or more aggressive mortgage. And so it's, depends on the times. And obviously the interest rate has to be recited. And the mortgagor must sign. The mortgagee doesn't need to sign, but the mortgagor does need to sign in that case. And so there's a document that backs up the security of the real estate. That's a promissory note, which for real estate we call a deed of trust. So the deed of trust documents the promissory note. So we talked about the promissory note, the deed of trust. It's filed in the deed of trust records with the county. So there's two sets of records. There's deed records, and then there's deed of trust records that are maintained by each county.